Hi guys! Welcome to another episode of Attorney Ja Vlogger, Law for the Everyday Layman. Today we continue with our discussion on the Securities Regulation Code, and we'll be talking about topics on the protection of shareholder interest as well as of the investing public in general. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. A like on this video or any of my other videos would also be greatly appreciated. Now, let's proceed with our discussion. As I mentioned in the previous videos of this series, the main objective of the SRC, the Securities Regulation Code, is the protection of the investing public. This, of course, includes the shareholders of the corporation itself. So the SRC has a whole chapter on protection of shareholder interests. One method of protecting shareholder interests is the tender offer rule. And what is a tender offer? A tender offer is a publicly announced intention by a person acting alone or in concert with other persons to acquire equity securities of a public company. It is a quick, enticing proposal to the shareholders of a corporation that they tender their shares for purchase by the offerer at a specified term. Actually, it's an upside-down term. I make the offer, you make the tender of shares. It is usually part of an attempt by the offerer to buy enough stock to control the corporation, such as a corporate takeover. Tender offers are regulated to prevent the stockholders of the target company from being misled by the offerer or the target's management. Therefore, a principal requirement of the law is the disclosure by the offerer of certain information about the offer, with a copy of such information being given or sent to the stockholders. Section 19 of the SRC and its implementing rules give us the situations where the person or group of persons would be required to make a tender offer for equity shares of a public company in an amount equal to the number of shares that the person intends to acquire. Now, these refer to mandatory tender offers, and they cover both direct and indirect acquisitions. Now, there are two main distinctions. If the proposed acquisition is only 15% of the equity securities, then only a declaration is needed to be filed with the SEC. If 35% or over 50% of the equity securities is intended to be acquired, then there are certain rules. Let's go through them. As I mentioned, if they intend to acquire 15% of equity securities in a public company in one or more transactions within a period of 12 months, they should file a declaration to that effect with the SEC. If they intend to acquire 35% of the outstanding voting shares or such outstanding voting shares that are sufficient to gain control of the board in a public company, then there it depends on the situation. If the acquisition will comprise one or more transactions within a period of 12 months, then they shall disclose such intention and they will contemporaneously make a tender offer for the percentage sought to all holders of such securities within the said period. Now, if the acquisition will be done through the exchange trading system, the stock exchange, then they shall not be required to make a tender offer even if they acquire the remainder through a block sale. If, after acquisition through the exchange trading system, they fail to acquire their target of 35% of such outstanding voting shares, that is sufficient to gain control of the board. And if the acquisition is done directly from one or more stockholders, then they shall be required to make a tender offer for all the outstanding voting shares. The sale of shares pursuant to the private transaction or block sale shall not be completed prior to the closing and completion of the tender offer. Now, if the acquisition will result in ownership of over 50% of the total outstanding equity securities of a public company, the acquirer shall be required to make a tender offer for all the outstanding equity securities to all remaining stockholders of the company at a price supported by a fairness opinion, which is provided by an independent financial advisor or any other equivalent third party. The acquirer in such a tender offer shall be required to accept all securities tendered. Now, the implementing rules gives us exemptions from the mandatory tender offer requirement. First, any purchase of securities from the unissued capital stock, provided that the acquisition will not result to 50% or more ownership of securities by the purchaser or such percentage that is sufficient to gain control of the board. Second, any purchase of securities from an increase in authorized capital stock. Third, purchase in connection with foreclosure proceedings involving a duly constituted pledge or security arrangement where the acquisition is made by the debtor or creditor. Fourth, purchases in connection with a privatization undertaken by the Philippine government. Fifth, purchases in connection with corporate rehabilitation under court supervision. Sixth, purchases in the open market at the prevailing market price. And seventh, merger or consolidation. Okay? So these situations are exempt from the mandatory tender offer requirement. Now, the issuer or the corporation itself may make a tender offer, which is essentially a buyback of its stock, okay? But it can only do so if it has unrestricted retained earnings in its books to cover the amount of shares to be purchased, and only for the following purposes, okay? Either to implement a stock option or stock purchase plan, to meet short-term obligations which can be settled by the reissuance of the repurchased shares, to pay dissenting or withdrawing stockholders who are entitled to payment for their shares, and other legitimate corporate purposes. Okay? This is consistent with what we have discussed in corporation law. Okay? So, a tender offer is made by filing with the SEC of a declaration to make a tender offer, furnishing the issuer or the originator of the security an annual report, including balance sheet, profit and loss statement, statement of cash flows for the last fiscal year, certified by an independent certified public accountant. I'll just say CPA from now on. A management discussion and analysis of results of operations, periodical reports for interim fiscal periods, current reports on significant developments of the issuer, and other documents that the SEC may require. No, I just gave the list. No, then all other requests or invitations for tender or materials making a tender offer or requesting or inviting letters of such a security, these must be published, meaning that any person making a tender offer should make an announcement of its intention to do so. So now let's discuss the period and manner of making tender offers. For the period, a tender offer shall, unless it is withdrawn, it shall remain open until the expiration of either, first, at least 20 business days from its commencement, provided of course that an offer should as much as possible be completed within 60 business days from the date of the intention to make such offer is publicly announced, or second, at least 10 business days from the date the notice of a change in the percentage of the class of securities being sought or in the consideration offered is first published, sent, or given to security holders. For the manner of payment, in a mandatory tender offer, the offeror shall be compelled to offer the highest price paid by him for such securities during the preceding 6 months. If the offer involves payment by transfer or allotment of securities, such securities must be valued on an equitable basis. The offeror in a tender offer shall permit the securities tendered to be withdrawn. Okay, pwedeng bawiin pa. Okay? First, at any time during the period such tender offer remains open, and second, if not yet accepted for payment, after the expiration of 60 business days from the commencement of the tender offer. Okay, so within those periods, the offeror shall allow the securities to be withdrawn, no? The tendered securities to be withdrawn. If the tender offer shall be for less than the total outstanding securities of a class, but a greater number of securities is tendered instead, no? Then the offerer shall be obliged to accept and pay the securities on a pro rata basis, disregarding fractions, according to the number of securities tendered by each security holder during the period in which the offer was open. In the event that the offeror in a tender offer increases the consideration offered after the tender offer has commenced, then of course, tinaasan na niya. He has to pay that, okay? He shall pay such increased consideration to all security holders whose tendered securities have been accepted for payment by such offeror, whether or not the securities were tendered prior to the variation of the tender offer's terms. Now, the offeror in a tender offer shall either pay the consideration offered or return the tendered securities not later than 10 business days after the termination or the withdrawal of the tender offer. Now, take note, no tender offer shall be made unless, first, it is open to all security holders of the class of securities subject to the tender offer, and the consideration paid to any security holder pursuant to the tender offer shall be the highest consideration paid to any other security holder during such tender offer. Now, the offeror shall not extend the period of a tender offer without prior clearance from the SEC and without issuing a notice of such extension, how? By publication in a national newspaper of general circulation. The notice shall include a disclosure of the number of securities deposited to date and shall be made public not later than the scheduled original expiration date of the offer. Now, a person may also make a voluntary tender offer. Earlier, we discussed the mandatory tender offer, and now we also have the voluntary tender offer. And the law gives us a presumption when a person will be presumed to be making a voluntary tender offer, in case the following factors are present. First, active and widespread solicitation of public shareholders for the shares of a public company. Second, solicitation made for a substantial percentage of the issuer's stock. Third, offer to purchase is made at a premium over the prevailing market price at a firm rather than negotiable terms. Fourth, an offer is contingent or dependent on the tender of a fixed number of shares. And or sixth, offer is only open for a limited period of time. The law also says that it shall be unlawful where a tender offer has commenced or is about to commence for, first, any person other than the tender offeror who is in possession of material non-public information relating to such tender offer to buy or sell the securities of the issuer that are sought or to be sought by such tender offer if such person knows or has reason to believe that the information is non-public and has been acquired directly or indirectly from the tender offeror, those acting on its behalf, the issuer of the securities, or any insider of such issuer. Okay, so that's the first prohibition on insider trading when it comes to tender offers. And second, any tender offeror, those acting on its behalf, the issuer of the securities, and any insider are prohibited from communicating material non-public information relating to the tender offer to any other person where such communication is likely to result in insider trading involving tender offers. Finally, the following acts are prohibited in any tender offer. First, to employ any device, scheme, or artifice to defraud any person. Second, to make any untrue statement of a material fact or to omit to state a material fact necessary in order to make those statements made in light of the circumstances under which they were made not misleading. Okay? Just in short, to state a material fact so that the statement will not be misleading. Okay? Or third, to engage in any act, practice, or course of business which operates or would operate as a fraud or deceit upon any person. Take note that if equity securities of a public company are purchased at threshold amounts provided for in the SRC and its implementing rules without complying with the tender offer requirements, then the SEC may, upon complaint, nullify such purchase and order the conduct of a tender offer without prejudice, of course, to the imposition of other sanctions under the law. Now, another measure of protection to investors are the rules on proxy solicitation, meaning any request for a proxy or authorization, which we have already discussed in corporation law. Just check out my playlist on the revised corporation code. And as such, it contains substantially the same principles. Of course, the bylaws of the corporation shall be controlling in determining the proper procedure to be followed in the execution and acceptance of proxies, provided, of course, that the minimum formalities of the revised corporation code and the SRC are complied with. Now, a proxy is a formal authorization from a stockholder that empowers someone to vote on their behalf. It also refers to the consent or authorization to act on behalf of the principal. And it also refers to the person itself, no? So it's the document and the person itself who is so authorized to vote on behalf of a stockholder. The law says that proxies must be in writing, signed by the stockholder or his duly authorized representative, and filed before the scheduled meeting before the corporate secretary. Unless otherwise provided for in the proxy, it shall be valid only for the meeting for which it is intended, and no proxy shall be valid and effective for a period longer than 5 years at one time. Okay? So, 5 years lang dapat ang validity niya. Now, the rules on proxy solicitation, they follow the traditional three-way approach. Okay, which first calls for a brief description of the matters to be considered, together with the action proposed to be taken by the holder of the proxy. Second, it requires the registrant, as a condition of its own solicitation, to mail to record owners the proxy material of any stockholder upon their request at their expense. And third, adopts a general fraud rule prohibiting the making of any materially false or misleading statement. Now, the issuance and solicitation of proxies are regulated in order to minimize, if not avoid, the abuse and misuse of the proxy device, because this may lead to the self-perpetuation and irresponsibility of management. So where an issuer corporation is going to conduct an annual or any other stockholder meeting, if you remember your corporation law, there should also be a notice of stockholders meeting given to the stockholders, which should also set a date, time, and place to validate the proxies. Okay, which should not be less than 5 days before the actual meeting. So the validation of the proxies should be done no less than 5 days before the actual meeting. Now, the issuer must first submit or file its preliminary or definitive information statement, proxy form, and all other materials to the SEC for approval before transmitting the same, whether in writing or verifiable soft copy, to every security holder of the class entitled to vote at least 15 business days prior to the meeting. Okay, so send it first to the SEC. SEC will approve. Then when approved, send it to the stockholders at least 15 days before the meeting. Okay, if there are any changes to be made within that time, then there is an additional requirement of publication of the SEC order granting the changes, and it must submit the updated version to the stockholders within 5 business days from approval. Okay, you have to construe this with the previous statement that it should be still 15 business days prior to the meeting. The SRC also says that a broker or dealer cannot give a proxy in respect of any security that it carries for the account of a customer without the express written authorization of such customer. In other words, if it wants to give a proxy, get the written authorization of the customer first. Now, the implementing rules contain prohibitions, and it says that no proxy shall confer authority first to vote for any person to any office for which a bona fide nominee is not named in the information statement or any material attached to it. Second, it's not allowed to vote with respect to more than one meeting and any of its adjournment unless a specific statement is made in the information statement and proxy form that the proxy is valid for more than one meeting, provided of course that no proxy shall be valid and effective for a period longer than 5 years from the date of the proxy, as I mentioned earlier. Or third, it is also prohibited to consent or authorize any action other than the action proposed to be taken in the information statement or matters that I just mentioned earlier, no? Likewise, false or misleading statements on material facts or the omission of necessary material facts are likewise prohibited. Now, some final notes on proxies. If the name of the proxy is left in blank, the person to whom it is given or the issuer corporation receiving the proxy is at liberty to fill in any name that they may choose. If a duly accomplished and executed proxy is undated, the postmark, or if it is not mailed, its actual date of presentation shall be considered as the true date. A proxy executed by a corporation shall be in the form of a board resolution duly certified by the corporate secretary or in a proxy form executed by a duly authorized corporate officer accompanied by the corporate secretary's certificate. If the bylaws provide for a cut-off date for the submission of proxies, the same should be strictly followed. In the absence of a provision in the bylaws fixing a deadline, then proxies shall be submitted not later than 10 days prior to the date of the stockholders' meeting. Where the corporation receives more than one proxy from the same stockholder and they are all undated, the postmark dates shall be considered. If the proxies are mailed on the same date, then the one bearing the latest time of day of the postmark will be counted. If the proxies are not mailed, then the time of their actual presentation is considered. That which is presented last will be recognized. Okay? Where the same stockholder gives 2 or more proxies, the latest one given is to be deemed to revoke all former proxies. Where a proxy is given to 2 or more persons in the alternative, okay, A or B, no? In one instrument, the proxy designated as an alternate can only act as proxy in the event of non-attendance of the other person. So in other words, A or B, B can only act if A does not attend. If the stockholder intends to designate several proxies, the number of shares of stock to be represented by each proxy shall be specifically indicated in the proxy form. If some of the proxy forms do not indicate the number of shares, the total shareholdings of the shareholders shall be tallied, and the balance thereof, if any, shall be allotted to the holder of the proxy form without the number of shares. If all are in blank, the stocks shall be distributed equally among the proxies, and the number of persons to be designated as proxies may be limited in the bylaws. Now, in case of shares of stock owned jointly by 2 or more persons, the consent of all co-owners shall be necessary to appoint or revoke a proxy. For persons owning shares in an and/or capacity, any one of them may appoint and revoke a proxy. Just review your oblicon as to why this is the case. And finally, on proxies, there shall be a presumption of regularity in the execution of proxies and shall be accepted if they have the appearance of prima facie authenticity in the absence of a timely and valid challenge. Now we can move on to the rules on internal record keeping and accounting controls. The SRC requires the following corporations to comply with Section 22. Take note of this because I will be referring to this later on again. An issuer which has sold a class of securities which is registered. Second, an issuer with a class of securities listed for trading on an exchange. And third, an issuer with assets of at least 50 million or such other amount as the SEC may prescribe and having 200 or more holders, each holding at least 100 shares of a class of its securities. Okay? That's in Section 17.2. Okay? And these corporations must comply with Section 22 and they are obliged to perform the following acts. First, they must make and keep books, records, and accounts which, in reasonable detail, accurately and fairly reflect the transactions and dispositions of assets of the issuer. They must also devise and maintain a system of internal accounting controls sufficient to provide reasonable assurances that transactions and access to assets are pursuant to management authorization, that financial statements are prepared in conformity with the generally accepted principles of accounting, okay, that are adopted by the Accounting Standards Council and the rules promulgated by the SEC with regard to the preparation of financial statements, and that recorded assets are compared with existing assets at reasonable intervals and the differences are reconciled. Now, let's move on to the next topic. The law says that every person who is directly or indirectly the beneficial owner of 10% or more of any class of any security of the corporations which I just mentioned earlier, okay? The issuer which has sold the class of securities, which is registered, etc. Okay? Any person who is directly or indirectly the beneficial owner of 10% of or more of any class of securities of the corporations I mentioned, or any director or officer of the issuer of such security shall perform the following acts. First, he should file a statement indicating the amount of securities of such issuer of which he is the beneficial owner. Okay, he should just say how many he owns, no? He should file that statement with the SEC and with the exchange if the security is listed on an exchange within 10 calendar days after the effective date of the registration statement for that security, or within 10 calendar days after he becomes such beneficial owner, director, or officer. Okay? If there has been any change in ownership, he should also file a statement indicating his ownership at the close of the calendar month and the changes that are made in his ownership that have occurred during that calendar month. He should file that statement with the SEC and with the exchange if the security is listed on an exchange. What period? Within 10 calendar days after the close of each calendar month thereafter, after the change occurred. Okay? Next, he must also notify the SEC if his direct or indirect beneficial ownership of securities falls below 10%, or if he ceases to be an officer or director of the issuer. However, a newly appointed officer who has no beneficial ownership over the shares of the company shall notify the SEC of such fact within 10 calendar days from such appointment. Now, if the security is listed on an exchange, the report shall be filed with that exchange in accordance with the rules of the exchange, but not more than 5 calendar days after such person becomes the beneficial owner. Now, in determining whether a person is the beneficial owner, directly or indirectly, of more than 10% of any class of any registered security, such class shall be deemed to consist of the amount of such class which has been issued. So, issued shares. Now, the foregoing rules that I just discussed, okay, is important because the SRC says that for the purpose of preventing the unfair use of information which may have been obtained by such beneficial owner, director, or officer by reason of his relationship to the issuer, then any profit realized by him from any purchase and sale or any sale and purchase of any equity security of such issuer within any period of less than 6 months shall inure to and be recoverable by the issuer irrespective of any intention of holding the security purchased or of not repurchasing the security sold for a period exceeding 6 months, unless such security was acquired in good faith in connection with a debt previously contracted. In other words, no, that very long statement, no? In other words, if a beneficial owner, director, or officer of securities enters into transaction over such securities, the issuer is allowed to recover the profit realized from such transactions within 6 months. If there was unfair use of information which was obtained from the relationship of such beneficial owner, director, or officer with the issuer. Okay? Nang dahil sa kanilang relasyon, may impormasyon siya kung kaya niya binenta. Okay? So, this is how the law protects the public, no, and prevents the unfair use of information. And for this purpose, for the purpose of the issuer recovering the profit, a case may be filed by the issuer or its representative before the RTC within 2 years from the date that the profit was realized. The SRC also makes it unlawful for any beneficial owner, director, or officer, whether directly or indirectly, to sell any equity security of such issuer if the person selling the security or his principal does not own the security sold, or if owning the security does not deliver it within 20 days from the sale, or does not, within 5 days after such sale, deposit it in the mail or other usual channel of transportation. He must prove that notwithstanding the exercise of good faith, he was unable to make such delivery or deposit within such time, or that to do so would cause undue inconvenience or expense. Okay? That's how he will avoid liability. Okay? To be exempt from the prohibition, he must prove that notwithstanding good faith, he was unable to make the delivery or deposit because of undue inconvenience. Not just any inconvenience, it must be undue inconvenience or expense. Now, let's go over some final matters. Let's talk about margin trading. Margin trading refers to the purchase of securities by an investor using the credit of the broker to pay for part of the securities. Margin trading is regulated to prevent the excessive use of credit or carrying of securities. The margin is the amount of money or securities that an investor must deposit with the broker to secure a loan from the broker. When a broker makes a demand on the investor to deposit money or securities with the broker, when a purchase is made, or when the investor's equity in a margin account declines below a minimum standard set by the exchange or the broker, then the broker is said to have made a margin call. The credit extended must be for an amount not greater than whichever is the higher of 65% of the current market price of the security, or 100% of the lowest market price of the security during the preceding 36 calendar months, but not greater than 75% of the current market price. And according to the case of Abacus Securities versus Ampil, trading on credit or margin trading allows the investors to buy more securities than their cash position would normally allow. Wala kang pera, bumibili ka. Or kulang pera mo. Investors pay only a portion of the purchase price of the securities, then their broker advances for them the balance of the purchase price and keeps the securities as collateral for the advance or the loan. The brokers take these securities to their bank and borrow the balance on it, since they have to pay in full the security. Okay? Hence, increasing margins, namely decreasing the amounts which brokers may lend for the speculative purchase and carrying of stocks, is the most direct and effective method of discouraging an abnormal attraction of funds into the stock market and achieving a more balanced use of such resources. Another topic on protection of the public that I want to talk about is the power of the SEC to suspend trading in a security or all trading on a securities exchange. If the SEC, in its opinion, finds it necessary or appropriate for the protection of investors and if the public interest so requires. The SEC may summarily suspend trading in any listed security on any exchange or other trading market for a period not exceeding 30 days. It may be longer if it is with the approval of the President, in which case the SEC may summarily suspend all trading on any securities exchange or other trading market for a period of more than 30 days but not exceeding 90 days. And if the SEC issues an order of suspension, it should notify the affected issuer of the reasons for such suspension, and it should provide them with an opportunity to be heard and determine whether or not the suspension should be lifted. Finally, to protect the public, and aside from the civil liabilities for false registration statements, those in connection with prospectus, communication, and reports, for fraud in security transactions, manipulation in security prices, insider trading, and commodity futures contracts and pre-need plans, the SRC, to protect investors, has also established a trust fund to be facilitated by the SEC. And this trust fund is established for the purpose of compensating investors for extraordinary losses or damages suffered by them due to business failure, fraud, or mismanagement of the persons with whom they contract. Okay? So that's it for this episode, guys. I hope you may have picked up a thing or two, and I hope to see you next time. See you soon, guys. Bye.